Okay, so in the last class we were talking about Article 1, which is, so Article 1 is the subject matter. Okay, we have talked about the subject matter for this regulation, and now we are going to talk about, so we had talked about the prohibitions, we have talked about this classification of prohibition of certain AI practices, high risk AI systems, harmonized transparency rules and certain AI systems, harmonized rules for placing on the market of general purpose AI models, and measures to support innovation. Okay. So, and of course, rules on market monitoring and surveillance and governance. Okay. We had also talked about various sections. So, we had also talked about, we had also listed these sections wherever we can find the details of these things. Okay. So, today we are going to start with the Article 2, which is scope. So, scope means where does this regulation apply? So, this regulation applies to, what was the definition of providers? So, there is no harm. We go back to the, so provider means a natural or legal person, public authority, agency or other body that develops an AI system. So, either you are developing an AI system or you have it developed from someone else. Okay. So, have it developed and places them on the market and puts system into service under its own name or trademark, whether for payment or free of charge. Okay. So, either you develop, you have it developed, and then you, so if you just develop and have it developed, that does not make you a provider, because you are just developing until you place them on the market or put them into service, okay, under your trademark or under your name or trademark, whether for payment or free of charge. So, we have seen what a provider is. Now, so provider means, so this regulation applies to providers placing on the market or putting into service AI systems or placing on the market general purpose AI models. So, we have listed where are these definitions now. I am not going to go over to them again and again. So, in the union, so providers, so this regulation applies to providers who are placing on the market or putting into service AI systems or placing on the market general purpose AI models in the union. Which union? European Union. Irrespective of whether those providers are established or who are located within the union or in a third country. So, what does it mean? Whom does it apply to? Yes, whom does it apply to? Right. So, whom does this regulation applies to? Providers. When you say providers, it automatically means they must be placing AI systems on the market or putting into service, okay, or placing on the market general purpose AI models. So, this is fine, irrespective of whether those providers are established or who are located within the union or in a third country. Okay. So, it does not matter. So, irrespective of whether those providers are established or who are located within the union or in a third country. Why should it be applicable to a third country? Why should it be applicable to, providers in the third country? Exactly, because you are putting on the EU market, You are placing them on the EU market. If you are not doing them on the EU market, then this is not actually applicable to you, right? So at least this particular part just says if you place a AI system, place on the market, put into service, okay, irrespective of whether you are established within the European Union or outside it, it does not matter as long as you are placing an AI on EU market, okay. Second, this regulation applies to deployers of AI systems that have their place of establishment or who are located within the Union. What does this mean now? What are deployers? So what were the other actors we had talked about? What are the different actors? Providers, deployers, importers, authorized representatives, distributors, okay, and finally all these were captured in one word called operators, okay. So deployers of AI system that have their place of establishment who are located within the Union. So this applies to providers. If you are making an AI and if you are placing that in the EU market, it does not matter where are you established, okay, irrespective of whether those providers are established or who are located within the Union or in a third country. So if you are a provider and if you are placing something on the EU market, this act applies to you. So if an Indian company places their AI on EU market, so is this Indian company governed by this law as far as AI is concerned? Yes, okay. What is the second thing? Deployer of AI systems that have their place of establishment or who are located within the Union. What does this mean now? The first one was for the providers. What is this for? Deployers. Now who are deployers? So a deployer means any natural or legal person, public authority, agency or other body using an AI system, so underscore this, using an AI system under its authority, except where the AI system is used in the course of a personal non-professional activity. So all those who are using it, okay, under its authority. Going back to what we were doing. Yes. So deployers of AI system that have their place of establishment or who are located within the Union. What does it mean now? It applies to all the providers that we understand. It does not matter where are you located or established. Now deployers of AI system. So deployers that are located within the European Union have their place of establishment who are located within the Union. So if I am a deployer in India, is this law applicable to me? No, okay. So a deployer must be located within the Union, but a provider need not be located, okay. Provider can be anywhere as long as you are placing your AI on the EU market, the law is applicable to you. But as a deployer, if you are not located in the European Union, then it is not applicable to you, okay. Providers and deployers of AI systems that have their place of establishment or who are located in a third country where the output produced by the system is used in the Union. What is this now? So this clause talks about just providers wherever they may be. This talks about deployers, but deployers must be located within the European Union. Now this talks about both of them. So providers and deployers of AI systems that have their place of establishment or who are located in a third country, okay. So we are specifically talking about providers and deployers that have their place of establishment or who are located in a third country outside EU, where the output produced by the system is used in the union? Any examples of this? Or which case is it capturing, which is not captured by these two? Right? Then how is this different from providers? Right, okay. So maybe let's make it more specific. Yes. See, providers and deployers of AI system that have their place of establishment or who are located in a third country. So we are specifically talking about providers and deployers. Okay. They are both located outside. See, this clause said providers can be anywhere. This clause said deployers should be in union. Now this clause is saying something more than what these two did not say. What is it? Providers and deployers of AI system that have their place of establishment or who are located in a third country, so not inside European Union, where the output produced by the system is used in the union. Output produced is used in the union means, see, how can one bypass these two if you don't have this clause? That is the question I want to ask. I mean, which case is this clause capturing? If you have just these two, how can companies play around with this regulation?
So let's say there is a company, AI company, distributed in US, and they are here. I am calling them and saying them, please generate me text for this. So, and the result, they are texting me.
Right.
Now I can use in UK and say then this AI company is not.
Right. So what can happen is, I am a provider not in EU, I am a deployer not in EU, and I can simply say that this law is not applicable to me, even though it might be impacting people in EU. So if the output produced is used in the EU, it does not matter where are you located, the law applies to you, right? Otherwise what can happen, like Ashutosh rightly said, a person or a company sitting in EU, right, gets services of a AI company in, let's say, India or USA, gets that data. So who is doing the processing on the behalf of this EU person? Company outside EU, right? They are doing everything that this, let's say, act prohibits. So you basically delegated this work to someone else who is not a provider in EU, who is not a deployer, right? But you are actually doing everything which is prohibited. So basically to stop such things from happening, this clause is there, that it does not matter whether deployer is outside EU, inside EU, provider is inside, outside EU, as long as the output is used in the EU, the law is applicable. So next, importers and distributors of AI systems. What were importers? We need to by heart these terms, even I don't exactly remember. So what were importers? So provider, deployer, authorized representatives, importer. So this line is common. Importer means any natural or legal person located or established in the EU that places on the market or an AI system that bears the name or trademark of a natural or legal person established outside the union, right? So similarly, what was distributor? Natural or legal person in the supply chain other than provider or the importer. So basically, again, why do we have this term? because entities may come and say, see, we are neither provider nor deployer nor importer, and hence the law does not apply to us. So this point specifically says, whosoever you are in this supply chain, right? You are, if you are not any one of these, then you are distributor, and hence the law applies to you as well. So it applies to importers and distributors of AI system. So who are importers and distributors actually? They are not the providers, but they are kind of the middle parties, right? Part of the supply chain. So product manufacturers placing on the market or putting into service an AI system together with their product and under their own name or trademark. So product manufacturers, right? What are product manufacturers? As such, there is no definition given, but what can product manufacturer be? See, important thing is here, so placing on the market, putting into service, this we have seen extensively by now. An AI system. Now, the line that is different and what we have not seen until now is together with their product under their own name. Okay. So you have a product. What it can be? For example, anything. Okay. So one is AI as a software. Another is you have a product in which you are using AI. Okay. Maybe some game or whatever.
These product manufacturers or innovators are same in this scenario?
Which innovator?
Like who's doing the innovation in the AI space? Are they same or?
No, product manufacturer. See, it can be something like, you are making, let's say, some kind of a product. It can be wheelchair, it can be, let's say, a toy. Okay, and if that uses AI, so you become product manufacturer of that particular thing, whatever product you are making, physical one.
Like what if I haven't built that AI software?
So if you don't integrate this with AI, this law will not be applicable. Of course, some other laws will be applicable, right? But this law will not be applicable because your product has nothing to do with AI. This law only comes in picture because you are basically integrating an AI system in your product. Okay? So this is done. Authorized representatives of providers which are not established in the union. So again, authorized representative of providers which are not established in the union. Now what does this mean? Okay, so I meant duplicate CC and not the not the exact term here. Yes. Yes. What is this first part? Authorized representatives of providers which are not established in the union. What does it mean, authorized representative of providers? So who are not established in the union? So in which case do you need authorized representatives? When providers are not located in the union. So when you are a provider, you are not established in the union, but your authorized representative is. So in that case, the the authorized representative is governed by this law. Affected persons that are located in the union. Okay, affected persons. So here again, person can be human beings or whatever. So that's it. Now, so here if you see, this particular thing says clause 1 or subarticle 1. So clause 1 basically says this regulation applies to all these things. Okay. Now you go here. So clause 2 is not completely applicable but partially. So how come? For AI systems classified as high risk AI systems, that we will see later. So for AI systems classified as high risk AI systems in accordance with articles of this regulation, will come to them, related to products covered by union harmonization legislation listed in annexure 2 section B, only article 84 of this regulation shall apply. So if you fall into one of those legislations which are listed in this annexure, then the whole act does not apply, only article 84 of this regulation shall apply. Article 53 shall apply only insofar as the requirements of high risk AI systems under this regulations have been integrated under the union harmonization legislation. So for us sitting outside EU, this requires a lot of knowledge of EU law. We don't have that. So what we are, all this regulation is saying is, if you are talking about a legislation that falls in this annexure, only article 84 and 53 may apply, all of it will not apply. What may be the reason for doing so? Because those legislations may already be asking you to do a lot of things. Okay? So you are already compliant with this act in some sense. Next, so now we start with the list of this regulation shall not apply. So it does not apply to these things, shall not apply to areas outside the scope of EU law, and in any event shall not affect the competences of member states concerning national security. See this word national security, see this is a, yes. So what you can do whatever on the name of national security anywhere, regardless of the type of entity trusted by the member states to carry out the task in relation to those competences. This regulation shall not apply to AI systems if and insofar placed on the market, put into service or used with or without modifications of such systems exclusively for military. So if military wants to use AI, this regulation does not apply. Defense or national security purposes, this regulation does not apply. Regardless of the type of entity carrying out these activities. What did you say? No, you said something. Huh? So to whom it is applicable then? Right. Okay. So to corporate sector, to individuals, but not on military, defense or national security purposes. By the way, why would you like to keep such exceptions? See, why do you think anybody would like to regulate AI? We have talked about this in the first class, right? But why do you think anybody would like to regulate AI?
Because they are scared.
Of?
Scared of the implications. Like it can be threatening to democracy in the biggest one.
See, the way you package is that you are supposed to protect the rights of your citizens, and to huge extent that is true as well. Okay, but if you exclusively in a law says it is applicable to military as well, that means your military. So this legislation will not apply to, for example, India. Now let us say tomorrow India starts making, weapons that use AI, right? Who will be on the back foot? Those that are not using AI for military, right? So those things are usually kept out of the scope of the all legislation. So in India, even if you talk about, so things, fundamental rights are granted to all citizens, but not to military personnel, right? The scope of the application of fundamental rights is much lesser compared to citizens for military personnel. So if you become a military personnel, this implies you are giving up on some of the fundamental rights. Okay? All right, so this regulation shall not apply to these things. So this is just a repetition, I think, this paragraph. So it's a long list of whom it does.
Then if I self-host, then would these all apply?
If I
Self-host any AI model.
I don't understand.
If I self-host any AI model,
What does this mean?
I will run my AI model uncensored on local systems.
Oh no, so
Then it will not apply.
no, so we'll come to that in today's class itself. Okay? Catch it. So he says he does not have a local system to do that, but okay. But so this does not, let's complete the list and we'll come to what you are saying. So this regulation shall not apply to public authorities, but in a third country, okay, nor to international organizations falling within the scope of this regulations. Now this is too much legal, let's not go there. What this line is saying, it is not applicable to public authorities in outside EU and international organizations. So give me example of this. Third country means now EU cannot make laws for Indian government, okay, or EU cannot make laws for UN, SAARC, BRICS and so on, okay. So this is all it means. Now rest are legal intricacies, let's not go in there.
Even if they made law for BRICS or whatever SAARC or UN,
Yes. So if you make a law for, outside your jurisdiction, what does that mean?
sanctioning.
No. You are making a mockery of yourself, na? Nobody's. So exactly, so you don't do that. So this regulation shall not affect the application of provisions of the liability of, again, so they are talking about some other EU law, so where it should not apply. So basically this law, so this also does not apply to the provisions of Digital Services Act that they have passed in as a different legislation. This regulation shall not apply to AI systems and models, including their outputs specifically developed and put into service for the sole purpose of scientific research and development. Okay? So if a university is developing an AI, see where is the problem? Initially we talked about this. If you place on the market, what was the other term? If you put into service and if you start using in some manners, right? As long as you are not making it available on the market, right, you should be reasonably safe as far as the application of this law is concerned. So it says, if you are doing sole purpose of scientific research and development, you can do whatever, but we'll see again there are limits. So again, union law on the protection of personal data. So which regulation they are talking about whenever you say protection of personal data? Which regulation? Heard of GDPR? GDPR. Okay. So it says, so this regulation shall not affect GDPR. This is GDPR. Okay. What does this mean? Basically personal data protection. GDPR stands for General Data Protection Regulation. So this regulation shall not apply to any research, testing, development activity regarding AI systems or models prior to being placed on the market or put into service. Those activities shall be conducted respecting applicable union law. The testing in real world conditions shall not be covered under this exemption. So whatever you are doing, so if you are a company, you are trying to build AI, that is fine. Problem is when you place it on the market. So whatever you are doing before that, it is fine.
So putting in AI, what a complete is it kind of putting it in the market?
So anybody in the public can use it, right? So then basically, yes.
But it's an open source project, anybody can contribute.
So we'll come to open source here as well. Okay. Whatever you said is partially covered here. The testing in real world conditions shall not be covered under this exemption, but partially, not. So this regulation is without prejudice to the rules laid down by UN legal acts related to consumer protection and product safety. This regulation shall not apply to obligations of deployers who are natural persons using AI systems in the course of a purely personal, non-professional activity. Okay. So what does this mean? So if you can develop AI in isolation, you can also use it in isolation as a human being, as a user. Okay. Now this regulation shall not preclude member states. This is important thing. So this regulation shall not preclude member states or the union from maintaining or introducing laws, regulations or administrative provisions which are more favorable to workers in terms of protecting their rights in respect of the use of AI systems by employers, or to engage or allow the application of collective agreements which are more favorable to workers. What does this mean? Who said? Yes. So basically, in a way, you are trying to protect your workforce. So this regulation does not preclude member states. Member state means how many countries are there in EU? 27. Obligations laid down in this regulation shall not apply to AI systems released under free and open source licenses unless they are placed on the market or put into service as high risk AI systems or an AI system that falls under title. So if you, whatever you are putting on GitHub, it does not fall under these two titles. So if that does not fall under the prohibited category and the high risk category, you should be fine. So for example, if you are developing a game that uses AI, right, and if you want to develop that on GitHub, that is fine. But if you are making an AI where you are trying to recognize emotion of students in a classroom, this comes under high risk and you can't do that.
पर्सनल यूजेस अगर हम कुछ भी डेवलप करते हैं वो यूज भी करते हैं इट इज कंप्लीटली फाइन इट डज नॉट कम टू द प्रॉब्लम बट अगर हम खुद से डीआईवाई गन बनाते हैं
say that again शुरू से
अगर हम उससे कोई gun-
starting
okay, अगर हम like एक AI model जो मैंने उससे develop करा है उसको use कर रहा हूँ, it does not come under this law.
as such no yes as such no I mean it should not be so that once the law enforcement agencies find you and they find that what you were doing was illegal.
Okay, तो मेरा क्वेश्चन ये था, मतलब मेरा क्वेश्चन ये था कि like अगर मैं एक गन बना रहा हूँ, जो मैंने खुद से बनाई है, but obviously it can harm, but that thing is being illegal, although मैंने खुद से करा है.
So if you are making a gun and the law says making a gun is illegal, then this activity in itself is illegal. Okay. So there are some okay. So any questions in what we have done until now? Because now article changes. Yes.
So, sir, there are some models like Dolphin Mistral.
There are Mistral. Huh.
Mistral, a Dolphin version of it, and you can ask anything like how to create bomb, guns, kind of uncensored completely. There should be this category, and still they are available.
See, there are models on darknet that will help you with whatever, right? So they are already illegal. I mean, you don't need this act, you know.
No, sir, then why they are available on GitHub very publicly, open source, and it's a very famous model as well. Still,
Right. Right. So it is publicly available on GitHub because there is no law in any country that regulates it. So whatever you are doing, as long as it is not illegal, right, you are not barred from doing it. That is the reason EU is coming up with this legislation, that there should be some kind of check on what you can do and what you cannot do.
So what if there is a law against it, then what people do, like they will remove it from the GitHub or what?
No. So for example, now what will happen? So now let's say this act comes. What will happen to the model that you are saying?
If this act comes,
Huh.
then they have to remove the model from the.
Right. But anybody has heard of the Pirate Bay? Where was this hosted? See, now you have dark web, but back in 2002, 2003, 2004 days, it was hosted in Sweden. Okay, because Sweden laws were very flexible, so you could host it. So what will you find on Pirate Bay? All movies and everything. Okay, so basically piracy is not allowed in US, not allowed in India, not allowed anywhere. But if a website is hosted in Sweden, then you get some kind of liberties. It's not that it's completely legal there, but the laws there were somewhat flexible. Now if so, it depends on, so whatever you said, if that deployer, that provider is in EU and are providing AI that comes under prohibited or high risk AI, right, EU itself should take it down. Okay, but let's say if you host this in somewhere outside EU, in India, then as such EU law enforcement agencies have no jurisdiction. And this problem of jurisdiction is one of the biggest reasons for cyber crime flourishing, because you do something sitting in country X, the money goes to country Y, it goes 10 rounds before going to Y and so on. So okay.
At least they can still block it in the EU, right?
They can still?
Block it in the EU. That
Yes.
certain content or-
Yes. I mean, at least this gives law enforcement agencies a way to crack down on that if they find this happened in EU. Without a law, you can't even do that. Okay. So definitions are something we won't do Individually we will do them when we encounter that term, and I think it's a, so let me go to last article for today, and this is something I really like about, you know, those who legislate. So this thing, this is article 4b. In this, see, we should not remember the article numbers in this document because this is not the final version. Eventually the article numbers will change, okay, they might change at least. So something on AI literacy, and this is something I find really beautiful. So it says providers and deployers of AI systems shall take measures to ensure to their best extent a sufficient level of AI literacy of their staff and other persons dealing with the operation and use of AI systems on their behalf, taking into account their technical knowledge, experience, education and training and the context the AI systems are to be used in, and considering the persons or group of persons on which AI systems are to be used. So they just don't throw a act upon you. What they are saying is, it is also the responsibility of providers and deployers to basically make their staff AI literate, what they call AI literacy, right. So I think this is a very good provision, because without this it's very difficult to enforce, because providers, deployers, their employees, they can simply get away by saying I did not know, okay. And on the other hand, I think more than, you know, regulatory, this is more of educative in nature. Okay. All right, so I think that's enough for today. What we'll do in the next class is title 2, which is prohibited artificial intelligence practices. Okay.